Good afternoon, everyone. And today's capital market hearing is hereby called to order. Today's subcommittee is entitled Legislative Proposals to Enhance Capital Formation and to Reduce Regulatory Burdens, Part 2. I welcome the esteemed panel and my colleagues who are here today. We will begin with opening statements. I will yield myself, how much time do I have? 3 minutes. And after we do opening statements, for those of you who have not been here before, then we'll be looking to you. So I'll yield myself 3 minutes at this point. And again, I wish everyone good afternoon. Today, the subcommittee meets for, as I said, the second time in as many weeks to explore several pieces, actually 4 pieces of legislation that would further reduce barriers to capital formation and to help to make the U.S. capital markets even more attractive to both companies and to investors. Now, the first of these bills is a discussion draft, which I have put forward. And what would it do? It would authorize the creation of and establish a regulatory framework, if you will, for what some have dubbed venture exchanges. So what are these venture exchanges, and what could they be, and why are they necessary? Well, to put it simply, they would be security exchanges specifically tailored to foster the secondary trading of securities for not the large cap, but for small caps and pre-IPO companies. As multiple witnesses have testified already to this committee over the years, our current equity market structures in many ways have disadvantages to small issuers who oftentimes find that their stocks are trading in illiquid markets with little to no research coverage. Now, this has the ultimate effect of raising the cost, therefore, of the capital for these companies and, of course, then impacts of their ability to grow and to then hire new workers. In many ways, creation of these new format or exchanges is a logical next step in the wake of the 2012 Jobs Act, which is now law. And while the Jobs Act did a great deal to facilitate primary offerings by companies, it really did comparatively little to address some of the structural issues that exist in the secondary market for the smaller companies. As SEC Commissioner Dan Gallagher put it in a speech last year, these exchanges would, quote, should bring market makers and analysts to these exchanges, thereby creating some of the ecosystem supportive of small companies that have been lost over the years, end quote. Under discussion draft, these venture exchanges would list securities such as those issued by emerging growth companies or Reg A+ issuers and would be exempt from certain SEC rules that are more befitting of large cap markets. Now, while this is the first time that this committee will consider legislation in this area, this idea is certainly not new and has gained significant amount of support in recent years as these markets for small companies have become more pronounced. And so I will look forward to exploring this, these 3 other draft bills, these other bills as well, offered by Mr. Hurt, Ms. Wagner, and Mr. Hill as well. And again, I want to thank all members of the panel and also the members of the committee and the sponsors of this bill. And with that, I will yield to the gentlelady from New York. 3 minutes? 5 minutes?
4 minutes.
4 minutes. Okay, we'll go for 4 minutes. We'll
anyway,
compromise right in the middle.
Thank you, Mr. Chairman, for calling this hearing for this review of these important bills, and I thank all the panelists for being here. Many of our colleagues are voting. They'll be coming back soon. While the system of securities laws in the United States is complex, the central tension underlying our securities law is simple. Investors want as much information as possible on the companies they're investing in as quickly and as accurately as possible. The companies that issue the securities, on the other hand, want to spend as little time as possible preparing the disclosures that investors crave. It is the job of public policy to strike the right balance between these competing desires. Most of the bills before us today would, in one way or another, alter the current balance between investor protection and lower cost for public companies. For example, the Accelerating Access to Capital Act would allow very small and thinly traded companies to sell securities using faster the self-registration process. This would no doubt reduce costs for these small companies, but it could also reduce key investor protections. Traditionally, registration has been limited to larger, well-known issuing companies that are widely followed by the markets. In 2007, the SEC decided to expand the number of companies who are eligible to use self-registration. In doing so, however, the SEC was careful to balance this against the need to maintain investor protection. The SEC was comfortable allowing certain very small companies to have a limited ability to use self-registration to offer securities to investors, but only on the condition that the company have at least one class of securities traded on the exchange. This was because the exchanges have their own standards that companies must meet in order to get their securities listed on the exchange, and these listing standards provided investors with sufficient assurance that the company is legitimate, has a reasonable wide investor base, and will have enough trading interest to assure a reasonable amount of liquidity in the stock. But this bill would do away with these protections and would allow very small companies that trade in over-the-counter markets and not on a registered exchange to sell securities using self-registration. Allowing a small company whose stock is very thinly traded to quickly sell a large amount of securities under a self-registration raises serious concerns about potential market manipulation. And I'd like to hear more from our witnesses about this issue. Another bill, the Fair Access to Investment Research Act, would extend the SEC's research safe harbor to allow broker-dealers to publish research on exchange-traded funds and other investment companies. I think that this is an interesting and worthwhile idea, and while I have some concerns with the way the bill is currently drafted, I hope that we can work together toward a solution that allows for more quality research on a fast-growing market, while also minimizing the potential for abuse. I look forward to hearing from the witnesses on all of these bills, and I yield back. Thank you.
Gentlelady yields back. Thank you very much. We now go for a minute to Ms. Wagner. Welcome.
Thank you, Mr. Chairman, for recognizing me for 1 minute today. We will be considering some important legislative proposals that will help facilitate capital formation and reduce regulatory burdens for small companies. My legislation, the Accelerating Access to Capital Act of 2015, will broaden eligibility for smaller companies to use Form S-3, a simplified registration document filed with the SEC that is currently available to larger companies. This will help get small companies off the sidelines and help them secure funding to grow their business and, more importantly, create jobs. The benefits of Form S-3 are that it allows forward incorporation by reference and enables companies to provide offerings off the shelf, giving them greater flexibility to time their issuances with favorable market conditions. These benefits allow companies to avoid delays and interruptions in the offering process, which preserve their continued access to capital while reducing costs and eliminating uncertainty relating to funding. I thank you, Mr. Chairman, and I yield back the balance of my time.
Gentlelady now yields back. And I believe that's all the opening statements we have, and we now turn to the witnesses. First, some of you have been here before. Other ones have not. For those who have not, your entire written record will be made part. Your entire written statement will be made part of the record. We'll yield now to you 5 minutes, and I believe in those machines there's in front of you a green, a yellow. I never looked on the other side yet, and a red light. The yellow comes on, I believe, at the 1-minute warning sign. And this room has better acoustics than the room we're about to go back to, so we always ask you to, for benefit of us who can't hear well, to, if you're able to, are you able to actually move those microphones at all on those things? So if you are, when your turn comes, to move them as close as you can. So with that, we're going to now begin from the representative from SIFMA, but before we do that, we have an introduction to be made, and I will yield to Ms. Wagner to make that introduction.
Thank you. A new panelist, Mr. Chairman. Today I'd like to introduce one of my constituents, Ron Kraszewski, as one of our witnesses, and welcome him before this subcommittee, sir. Ron currently serves as chairman of the board of directors at Stifel Nicolaus, a brokerage and investment and banking firm in my hometown of St. Louis, Missouri, after first joining the firm as CEO in 1997. In addition to his prominent involvement in the industry, such as currently serving on SIFMA's board of directors and being appointed by the St. Louis Federal Reserve Board to a term on the Federal Reserve Advisory Council, Mr. Kraszewski has also played an active role in the St. Louis community. I thank you, Ron, for joining us here today, for doing your civic duty in coming before Congress. And with that, I yield back the balance of my time.
Gentlelady yields back. And, sir, you are now recognized for 5 minutes, and welcome.
Thank you, Congresswoman Wagner. Chairman Garrett, Ranking Member Maloney, and distinguished members of the subcommittee, thank you for providing me the opportunity to testify today on behalf of SIFMA and share our views on such a critically important topic. As introduced, my name is Ron Kraszewski, Chairman of Stifel. We're a 125-year-old investment banking firm based in St. Louis, which I've had the privilege of leading for 19 years. To put any discussion of capital formation in context, I would note that the securities industry sits at the fulcrum between investors and those in search of capital. On one hand, the U.S. securities industry employs nearly 900,000 people in 4,000 registered broker-dealers, serving clients with $16 trillion in assets. On the other hand, the industry in aggregate has raised $2.4 trillion for businesses and municipalities in the U.S. in the last year alone. For those reasons, the work this committee is doing to fine-tune and improve our securities laws is important and appropriate. We applaud your focus on promoting capital formation and decreasing burdensome friction in the securities laws while upholding necessary customer protections. Market reforms like decimalization, Sarbanes-Oxley, and various SEC rulemaking and disclosure requirements have produced benefits for investors, but have also resulted in unintended obstacles standing in the way of capital formation, creating a one-size-fits-all market structure that often fails to provide adequate flexibility for small-cap issuers. Because of the leadership of this committee, we have the Jobs Act, the tick size pilot, and the public debate with respect to capital formation, which I know is alive and well. Turning to the specific subject of today's hearings, I'd like to discuss two proposals that are illustrative of how Congress can and should influence SEC's capital formation agenda. SIFMA strongly supports Congressman Hill's legislation to provide access to research. Anomalies and conflicts in current regulation result in disparate treatment for research on different types of securities. Legislation appears to be necessary to spur action at the SEC because they have failed to create a safe harbor for research on ETFs or other open-end funds, even though the need to provide clarity has been on their radar for decades, and the impacted product has exploded in popularity, growing tenfold over the past decade to reach $1.6 trillion in 2013. Similarly, we understand Congressman Huizenga's legislation to deregulate the M&A broker industry was influential in spurring the SEC to action. Back in January 2014, just weeks after this committee passed Congressman Huizenga's legislation, the SEC issued a no-action letter regarding M&A brokers. This no-action letter stemmed from more than a decade of SEC discussion and consideration of this issue. Therefore, we believe it is premature to legislate an overriding and permanent form of relief on an issue where the SEC has already acted. SIFMA has also been asked to comment on the discussion draft to establish venture exchanges put forward by Chairman Garrett. We appreciate the focus on market liquidity for smaller companies and support all efforts to rebuild the ecosystem for small companies. SIFMA supports the SEC moving forward with a study of innovative ideas to improve liquidity in small and mid-cap stocks, but any prescriptive solution that risks damaging the competition in our equity markets that has fueled innovation needs to be carefully considered. It is critical that any changes to market structure for less liquid securities be considered to avoid the unintended consequence of impeding competition in the name of possibly increasing liquidity. SIFMA and its member firms are committed to working with Chairman Garrett to ensure that the legislation establishes a regulatory regime for venture exchanges that is both workable and efficient for all market participants. Additionally, SIFMA is supportive of Congressman Hurt's effort to ensure that reviews of the SEC rulebook are conducted on a regular basis. We strongly believe that regulators need to review the interplay between the rules and their aggregate effects rather than each rule in isolation. SIFMA is joined in this view by the administration as demonstrated by the recent executive orders. The members of this committee are to be commended for working together in a bipartisan manner to identify problems and develop solutions to improve capital formation and job creation in America. Our robust capital markets distinguish our economy from every other on earth, but without consistent attention and improvement will not be as efficient as possible. Thank you for the privilege to testify, and I look forward to your questions.
Thank you very much. Now, hear from Heritage. Mr. Burton, welcome to the panel, and you're recognized for 5.
Now it's working. Thank you, Mr. Chairman, Ranking Member Maloney, and members of the subcommittee. My name is David Burton. I'm a senior fellow in economic policy at the Heritage Foundation. The views I express in this testimony are my own and should not be construed as representing any official position of the Heritage Foundation. The focus of my testimony today is going to be on the secondary market for securities, with a particular focus on Chairman Garrett's discussion draft of the Main Street Growth Act, which would establish venture exchanges. Improving the secondary market for small capitalization firms will help investors and help them achieve a higher rate of return and reduce risk. It will improve entrepreneurs' ability to raise capital, and it will also promote innovation, lower costs, innovation with respect to production processes, and new products for consumers, and generally enhance prosperity in the United States. There are 3 key steps, in my view, to improving the secondary market for small firms. One is improving the regulatory environment for existing non-exchange over-the-counter ATS securities. This can primarily be achieved by providing exemption from onerous blue sky laws with respect to primary and secondary securities for companies that have continuing reporting obligations, which would include small public companies, but also the new Regulation A Tier 2 companies, as well as potentially crowdfunding companies if that regulation is ever issued. We could also improve the markets by reestablishing a list of marginable OTC securities that existed before NASDAQ made the transformation from a broker-dealer market to an exchange that was maintained by the Federal Reserve. And we could remove impediments to market making by dealers, particularly in thinly capitalized stocks, caused by regulations, SHO's requirement that broker-dealers cover their short position within 3 days. The second thing we can do, and I'll talk mostly about, is establish venture exchanges. The third thing we can do is improve the secondary market for private resales, including the codification of Section 4A 1.5, and with a particular focus making sure that platforms that facilitate those transactions are covered by the statutory exemption. Now, the discussion draft that Chairman Garrett came up with is a very positive framework for establishing venture exchanges. I have a few recommendations on things that would make it work better. Probably the most, or the first, would be changing the definition of venture exchange. It incorporates by reference the Title I definition of emerging growth company, which has a 5-year time limit, and I don't think we necessarily want to limit the ability of firms to participate on these venture exchanges to only 5 years. That has a relatively easy fix. Just alter the definition to by eliminating the 5-year requirement in emerging growth companies. Again, changing regulation SHO with respect to market makers in effect holding short positions so they can meet buy orders. Making it clear that the large exchange listing requirements that are in Section 18B1B with respect to covered securities don't apply to securities in the venture exchanges. Is I think very important that get handled, and it's somewhat it's not self-evident when you're thinking about these things. And then the last thing I'd raise is permitting market makers or market maker support programs, so that an issuer that wants to engage market makers and get an active market made in its securities can compensate the broker-dealer both to make markets and also to provide research in the security potentially. And with that, I'll close my statement, and appreciate the opportunity to testify today.
Great. Thanks for your testimony. Professor Bullard from the University of Mississippi, welcome to the panel, and you're recognized for 5 minutes.
Thanks very much. Chairman Garrett, Ranking Member Maloney, and members of the subcommittee, thank you for the opportunity to appear before you today. I am going to briefly summarize my thoughts on the 4 bills before the committee today, and although I don't necessarily agree with all of them, I certainly commend the subcommittee for diligently seeking to improve and modernize the federal securities laws. I have two general thoughts that apply broadly to these bills, as well as some that have become law. The first goes to the public-private distinction for securities offerings and issuers on which the federal securities laws are based. Recent legislation and recent bills are threatening to undermine the integrity of that construct by creating conflicting standards. Those who seek further reform should consider an omnibus bill similar to the approach taken when the federal securities laws were first enacted. The second broad point goes to the role of regulation and regulators. Legislation is getting too far into the weeds, where the SEC can simply do a better job. The crowdfunding bill is an example of what can go wrong when Congress attempts to draft detailed rules. Also, statutes are inherently poor vehicles for complex regulation. Congress should lay down broad principles and allow or direct the SEC to implement them. As for the bills before the panel, the one that most concerns me is the Accelerating Access to Capital Act. The Act would allow issuers, reporting issuers, to conduct shelf offerings where they have a public float of less than $75 million and are not exchange traded. Shelf offerings are intended to shorten the time needed to raise capital in the public markets, which generally allows issuers to take advantage of favorable market conditions. This means, of course, that when issuers are able to sell at a higher price, investors are also buying at a higher price. This is not such a concern when stock prices bear some rational relationship to intrinsic value, but non-exchange traded microcap stock prices are extremely volatile and highly illiquid, and their investment returns look more like a lottery than a market. Providing high-speed vehicle for microcap offerings will inevitably result in sales at grossly inflated prices. Volatility, illiquidity, and lottery-like returns also make non-exchange traded microcap stocks the favorite playground of market manipulators. While microcap stocks constitute a tiny part of the market, they represent an overwhelming majority of enforcement actions for market manipulation. The same characteristics that make shelf offerings riskier, high volatility, pricing inefficiency, investment returns with extreme outliers, make microcap stocks attractive candidates for market manipulators. The SEC carefully crafted the shelf offering eligibility test that the Act would weaken, and it did so as part of an ongoing review that has demonstrated sensitivity and responsiveness to the concerns of small businesses. The Act is an example of micromanaging securities regulation that is better left to rules and regulators. The Fair Access to Investment Research Act correctly reflects the failure of the SEC to regulate research conflicts as to registered investment companies and ETFs to appropriately reflect the difference between those and other securities. And I agree that ETF research regulation should be less restrictive. However, the Act uses a nuclear bomb where a mallet and a chisel are needed. It also uses legislation in an area that calls for the kind of flexibility that only regulations can provide. Regarding the Venture Exchange Act, Congress has historically allowed the SEC substantial leeway to regulate securities exchanges. The SEC has continuously and effectively exercised that authority to create a remarkably broad range of options for exchange operators, issuers, and investors. In the Act, Congress takes the opposite approach by assuming the role of regulator and dictating specific operational characteristics of the exchange. The requirement of pricing in nickel increments, for example, directly conflicts with the SEC's pilot nickel pricing program. The wholesale exemption from both Reg NMS and Reg ATS is unwarranted, as I believe at least Mr. Burton on this panel agrees. Finally, the Regulatory Review Act requires the SEC review its rules every 10 years, and this is exactly what the SEC should do. However, the SEC is already subject to retrospective rule requirements that make the Act unnecessary. In addition, I've made a number of suggestions in my written statement that would make the Act more workable. Thank you again for the opportunity to appear before the committee today, and again for your ongoing commitment to the revision of the federal securities laws. I'd be happy to answer questions about these bills or any others that are before the subcommittee.
Gentleman yields back. From the chamber, Mr. Quadden, welcome.
Thank you, Mr. Chairman, Ranking Member Maloney, members of the subcommittee. Thank you again for the opportunity to testify before you today here at Part 2 of the hearing. And at Part 1 of the hearing 2 weeks ago, I talked about the need to generate long-term economic growth and job creation, and that in order to do so, businesses must have the tools and opportunity to grow from small to large. Efficient capital markets that are liquid, deep, and well-regulated are a key for this growth to occur. I'm also a fan of the ideal espoused by Justice Oliver Wendell Holmes that the free marketplace of ideas is where the best ideas should come out to the fore. The bills that are before us today meet that ideal, and also advance the efficient capital markets we need through innovation, injecting competition, and giving regulators the tools to keep up with dynamic markets. The SEC retrospective review bill drafted by Mr. Hurt is needed because past efforts at retrospective reviews by the SEC have either been ignored or been ineffectual at best. The Jobs Act and the discussions that we've been having the last several weeks about a Jobs Act 2.0 are needed because of the failure of the SEC to ever conduct such a rule or to modernize its regulations. This bill will allow for a periodic review to ensure that regulations are meeting their intended purpose, whether or not changes are needed, or if rules are obsolete, that they be removed from the books. I would suggest 4 changes to improve the draft bill. First, regulations should be prioritized, that the regulations that are economically significant should be reviewed first. That is, using that term economically significant, are those regulations that cost the economy $100 million or more, and that is a term that is used in different legislation such as with UMRA or SPREFA. Secondly, rules should be prioritized with thresholds that have not been adjusted for 20 years. Again, an example is Reg A, or as we were discussing 2 weeks ago, the Rule 701 thresholds that have not been adjusted since 1988, making it more difficult for companies to attract and retain talent. Third, a retrospective review should undergo public notice and comment process as provided by the Administrative Procedures Act. Such a notice and comment process will allow the SEC to get informed commentary from a wide variety of stakeholders. This will also prevent what has submarined other retrospective reviews, namely that it gets shuffled into a staff-driven process and is quietly ignored. Fourth, entities that have delegated powers, such as FINRA or the PCAOB as examples, should also be included in such a retrospective review, since in fact their standard setting or rulemaking can be as economically significant as regulations drafted by the SEC. The Main Street Growth Act, drafted by Chairman Garrett, would authorize venture exchanges to help drive liquidity to companies that are going public. This should be also viewed in the context of creating a competing system with the OTC markets and alternative trading systems. We believe the bill should be adjusted to give exchanges and the SEC the flexibility to develop systems to efficiently match investors and businesses. Additionally, we would ask that there be authorized a retrospective study to look at past efforts such as the American Stock Exchange, AIM in London, Boston Exchange, to find out what worked, but most importantly, what did not work. Secondly, we think there should also be authorized under the bill a prospective study to collect data by a date certain to see if venture exchanges are working, as well as how they are operating in conjunction with the OTC market systems and ATS. This is similar to what is in the tick size pilot program. Finally, the other 2 bills before us, the Fair Access to Investment Research Act by Congressman Hill. We believe that this is a common sense change that will provide more information to investors to assist their decision making. Additionally, the Accelerating Access to Capital Act by Congresswoman Wagner would modernize the use of registration to allow businesses to become public companies faster, assisting liquid markets. Thank you again for the opportunity to testify on these bills, and I'm happy to take any questions you may have.
And again, thank you for your testimony. Mr. Wield, welcome to the panel, and you are recognized now for 5 minutes. Thank you.
Thank you, Chairman Garrett and Ranking Member Maloney. Members of the distinguished subcommittee, thank you for inviting me to speak today at this important hearing. My name is David Wield. I'm Chairman and CEO of Wield & Co. I was formerly Vice Chairman of the NASDAQ stock market with responsibility for all of its listed companies, and I ran the equity new issues business at Prudential Securities. The Main Street Growth Act, which is going to be the focus of my comments, will establish a new class of stock exchanges catering to the needs of small-cap companies and their investors. It is the potential to go down as one of the most important acts to come out of this or any Congress by creating essential infrastructure to support U.S. economic growth, bring back American entrepreneurial swagger, reignite the American dream, and create millions of jobs. When corporations access capital, they hire people. Those people spend money on the economy, and everything from lawyers and accountants to construction workers and restaurant workers. There's a multiplier effect. The benefits become widespread. Startups, according to the economist Robert Lighton, have collapsed from nearly 15% of all companies in the late 1970s to just 18% by 2011. For the first time in 3 decades, business deaths exceeded business births. In our published studies, we have documented a collapse in the number of small IPOs, a collapse in the number of publicly listed companies, a collapse in the number of small IPO book-running investment banks from 164 in 1994 to only 31 in 2014. One-size-fits-all U.S. stock markets have been a disaster for our economy. The Main Street Growth Act would reverse this by establishing an alternative market structure, one allowing its sponsors broad discretion in addressing the needs of small-cap companies, their investors, and the broker-dealers, research providers, and market makers needed to support them. This is a noble and important act for the American people, and it deserves the attention and support of both parties. I offer the following improvements to the Act. Some are similar to what David said from Heritage Foundation. One is that venture exchanges should be opened up to all currently reporting SEC-registered U.S. companies that are under $2 billion in equity market value or have less than $1 billion in revenue and are public for 5 years or less. That's the EGC definition. But to his point, it really should be broadened, and people shouldn't automatically just be pushed off the exchange. A venture exchange could help already public companies attract new investors, attract research coverage that they so desperately need, improve share prices, and lower the cost of growth capital. Secondly, create an orderly transition for companies to graduate from a venture exchange. Companies should be permitted to stay on a venture exchange, for example, until they have some higher threshold, have met some higher threshold, say $2.5 billion for 12 consecutive months. Third, explicitly permit broker-dealer member-owned venture exchanges. And 4, finally, we recommend that listing thresholds be adjusted annually for inflation. Consumers, investors, and the poor are harmed by low-cost, one-size-fits-all stock markets. This is what I refer to as the low-cost paradox of small-cap markets. The lack of sufficient aftermarket economic incentives causes broker-dealers and institutional investors to pull out of these markets. The Main Street Growth Act will reverse this harm. Consumers will benefit as more companies are able to access equity capital. More new companies means more competition and innovation. Thus, the apparently simple, unarguable benefit of low-cost trading has paradoxically harmed the consumer by causing a collapse in the capital markets, the capital formation infrastructure of our economy. Venture exchanges, by improving access to equity capital, will support the scientists, engineers, and entrepreneurs who will find cures to cancer, global warming, and the other great challenges that we face. Investors will benefit as the trajectory of long-term economic growth will be tilted upward by improving the rate at which startups are created and by improving the rate at which companies go public to free up more equity capital for investors to reinvest and start new companies. And finally, the poor will benefit, and I've said this to members of the Black Caucus, and I will repeat it here. African Americans, according to the Pew Institute, have an average net worth of only $11,000 as of 2013. They are not day trading stocks, as they simply don't have enough money to be invested in the stock market. Thus, they derive no personal benefit from low-cost trading, but poor people do need jobs. They need higher wages, and these are things that venture exchanges and the Main Street Growth Act can bring in time. I believe that the Main Street Growth Act will help create a better future for all of America's children. It's in that spirit that I brought my 14-year-old son here today to leave a lasting legacy for future generations of a better, more competitive America filled with opportunity for all. And I urge both parties, Democrats and Republicans, to come together and pass this important act because I think, really sincerely, America's future will greatly benefit from it. Thank you.
Thank you, Mr. Wield, and your son also for joining with us tonight as well. So I thank the panel, and I will begin by yielding myself 5 minutes. So just in case anyone missed it, Mr. Wield, you gave actually one of the most comprehensive statements with attachments, some charts and what have you. But let's not miss your second paragraph, second sentence of your statement. I just take this one at random here. This has the potential to go down as one of the most important acts to come out of this or any Congress by creating essential infrastructure in support of economic growth. In case anyone missed that point, I just wanted to reemphasize that. So thank you for that. Now that I have humility, I always say I have everything. So to get to it, first of all, where are we, in a sentence or two, so we don't have much time, where are we right now with regard to not venture exchanges? We don't have venture exchanges per se, but we do have small cap companies trading elsewhere. In a sentence, explain where that market is right now.
Well, small cap markets trade on either the low end of the NASDAQ or the low end of the New York Stock Exchange or in the over-the-counter market, and those markets are really pretty dysfunctional many times because they're what academics call asymmetrical order book markets, big buyers, no sellers. They need intermediaries to create liquidity, and since there's no economic model to support that, a lot of that liquidity isn't there, and so institutions have actually progressively moved capital out of small cap stocks over time.
Okay, so that's where we are right now. I'm going to jump back and forth. Mr. Burton, you list like 1, 2, or 3 different things that we could do. You're supportive of the bill, but you say with 1, 2, 3 things to do. What we do in this bill, and it's just a draft, is to set up exchanges, right? What your suggestions are, you could do this with exchanges. And I'll back to Mr. Wield again on this as well. Do you need exchanges in order to get this done? Button, yeah.
Yeah. I think it's the exchanges are very positive. It would create an alternative framework that private actors may decide is the best way to go. And we do have an established OTC market today, and making that work better is also positive, and it has one advantage over the exchange approach, namely it can be done immediately and is self-effectuating. The exchange process, while it's very positive, is going to take time because the SEC has to write rules, and then private actors have to establish the exchange rules and get them up and running and raise the capital to make it happen.
Well, let me just jump in there. Just a real side note, Professor Bollard, you raised the suggestion that we get into the weeds too much in some of these bills. And maybe real quick to Mr. Quadman, only a sentence each. We saw with Jobs Act 1.0 that we're waiting 2+ years after the fact, and we still don't have the regs, even though that passed this bipartisan and the President signed it, everybody was on board. You will agree that sometime the regulators don't actually work in a timely manner, even though when Congress is explicit as to what they want them to do and set more than just the principles, but they're explicitly what they want in a bipartisan manner. You'll agree with that, won't you?
I agree with that.
Okay. And so, Mr. Quadman, then, is there a time and place where we need to dig down a little bit in the legislation, whether it's my bill or some of these other ones, to actually specify exactly what we want more than just principled?
Yes, and I think what you're doing with your bill and with the other bills, you are setting out those broad policy directives and letting the SEC work out the details.
Okay, then running down to Mr. Wield. So on ours, and I'm still trying to get this picture in my mind, I'm asking help on all these things, is to try to see this continuum of where we are, continuum as far as what the market is made up of, okay? What the listing of the exemptions that we need to have in order to facilitate this, and what we need to make sure that you don't actually drive out, either kill some of the markets that are working good today, right?
Right.
But also maybe to facilitate it going forward. So is that where we really want to have maybe a continuum in the opportunity for doing this with exchanges being a piece?
Well,
is that clear?
I think that the beauty of an exchange solution that's focused on, just to give you a statistic, about 80% of listed companies are sub $2 billion in market value, but they only represent about 66% of total market value. I mean, so they're very different than large cap S&P 500 stocks. So to create an institutionalized solution where people are focusing explicitly on the needs of this very different, group of stocks and their ecosystem, I think will actually set this country's stage so that we actually can drive a lot more economic growth, a lot more capital formation into companies a lot sooner, which in turn will trickle down and start creating a higher startup rate,
okay,
and get our entrepreneurial mojo back.
There you go. To coin a phrase. So I'll end with Ron, at the end of the panel.
Ron's fine.
Ron, yeah, thanks. I was going to call you Ron. It didn't seem appropriate.
That's
you
fine.
Just want to comment last?
No, all the things you've been reading about over the last 15 years, from flash boys to everything else, what's happened is that market structure has gone towards speed. in many things while destroying ecosystem for small companies. And this idea in recreating an ecosystem for small companies to have liquidity is extremely important. Of course, the devil's in the details, and that's where it lies. But without question, this needs to be done.
Great. Thank you very much. Appreciate the panel. With that, I yield to the gentlelady from New York for 5 minutes.
Thank you very much. Professor Bullard, I'd like to ask you about the ETF research bill. I support the concept of reforming the rules for research reports on investment companies like ETFs, but I share many of the concerns with the current draft of the bill that you outlined in your testimony. So my question is, wouldn't we be better off simply directing the SEC to amend the Rule 139 safe harbor for research reports to include registered investment companies subject to the appropriate conditions?
Yes, ma'am. There's a lot that needs to be done with respect to registered investment companies, not just ETFs, because I think the proposers of the bill certainly recognize correctly that they present very different risks. The problem with research reports is essentially that they become advertising in a form of underwriting message with respect to offerings, whereas registered investment companies, although continuously in registration, do not present the same risks. And I agree, although it hasn't been decades that the SEC hasn't acted on ETF research reports, that it needs to do so, and it may very well need to be ordered by Congress to do so. I think clearly the SEC has become dysfunctional in terms of doing its rulemaking. I think that you've got to look at the leadership of the SEC to answer the question of why that's happening. But that in principle does not mean that the Congress should step in and do detailed rulemaking, such as, for example, Mr. Quadman said that the Main Street Growth Act applies broad policy directives. I'd like to know from him whether prohibiting penny pricing, requiring nickel pricing, prohibiting sending information to a securities information processor, how those are broad policy objectives. Thank you.
Also, Professor Bullard, on the Accelerating Access to Capital Act, you noted in your testimony that the SEC requires companies to be exchange traded before they can use shelf registration to sell securities, because the exchanges have their own investor protection requirements that companies have to meet. Can you describe some of these standards that the exchange traded requirement brings with it, and why are they so important?
The exchanges typically impose various governance requirements, certain rights for shareholders. They have what are called as listing requirements that applies to the size of the company. And as a practical matter, we know empirically that they offer the kind of trading and liquidity that's been an issue at this table that is indicative of a market price. But if you look at the empirical research on non-exchange traded OTC stocks, you see exactly the opposite. You see study after study demonstrating that these stocks are highly illiquid, they are extremely volatile, they have lottery-like returns in the sense of having huge variance in their returns. As a group, the pink sheets are generally having negative performance. Now, I think I agree with the panel. Those problems need to be solved, but they're not going to be solved by the approach that's taken by this bill.
So if we get rid of the exchange-traded requirement, do you think that the risks to investor protection would outweigh the benefits to the companies?
Absolutely. What it would allow is non-exchange-traded companies, limited at least currently only by the 33 1/3% cap on their previous offerings, to make offerings with immediate access to an on-ramp in an environment where virtually all of their prices, when there is trading, is fluctuating wildly. And it's not clear to me why you would want to allow somebody to get even faster access to take advantage of market conditions when, by definition, the market conditions that are favorable to that kind of company are when it is trading at its peak, and studies show that that peak has very little to do with intrinsic value.
Thank you. And Mr. Krzyzewski, I'd like to ask you about the M&A broker bill. I noticed in your testimony that SIFMA has significant concerns with the bill, and I'd like to understand them a little better. It's my understanding is that after the Financial Services Committee passed a similar bill last Congress, the SEC took action on this by issuing a no-action letter that provided relief to small M&A brokers. But the SEC's no-action letter included 10 additional conditions to protect buyers and sellers that this bill does not include. So I have two questions for you. Is this bill even necessary anymore now that the SEC has already granted relief?
Well, no. I mean, the SEC, well, what this bill does effectively, in my opinion, is deregulate M&A across the board. At the thresholds of $25 million of EBITDA can be billion-dollar companies. At one point, Facebook had no EBITDA and had a market cap privately of well excess of $1 billion. And there are investor and buyer and seller protections, which being registered is important. The idea that the friction should be reduced for selling the local hardware company is notable and is understandable, but the bill far goes beyond that by almost deregulating all large private M&A.
Wow. And also, my time is up, but I'd like a clarification. This bill doesn't include several important protections that the SEC so-called no action letter does include. Would passing the bill have the effect of removing protections that the SEC has deemed to be necessary?
Effectively, yes, because the passing of the bill would make the institutions not subject to broker-dealer requirements. So effectively, it removes the protections that the SEC outlines in the no action letter from the marketplace.
My time has expired. Thank you very much.
Thank you. The gentlelady yields back. And before I say, I just want clarification on the record. Professor Bollard says that our bill prohibits data from going to the SIP. Actually, the legislation says that they shall not be required to submit any of that information. So not being required to is different from saying that you can't submit the data. So actually, they could still be doing it. With that, I will yield now to 5 minutes to the Vice Chairman of the committee.
Thank you, Mr. Chairman, and I thank you for holding this hearing. I also thank you for putting up for consideration today a bill that we have submitted relating to a 10-year retrospective review at the SEC of rules that have been adopted there. It seems to me that in its effort to protect investors, maintain efficient markets, and promote capital formation, that this is a common sense piece of legislation that should be well received. And I thank all of you who have commented on it for today's hearing. Mr. Bullard indicates, although he does offer some kind suggestions, if we proceed with the legislation, he begins with a premise with the premise that it's not necessary. And I guess I'd like to hear from Mr. Kruszewski and Mr. Quadman about whether this is necessary. Do we need to have a 10-year review of regulations and rules at the SEC? And if so, why so? And do we have other examples where agencies have been asked to do this where you've had positive results? And so maybe we could go to Mr. Kruszewski and then Mr. Quadman.
Well, your bill is very common sense. It is, and the question as to whether it's needed, I would just look at the fact that both the administration and everything I've read suggests that it should be done. It just hasn't been done. So, And
just for the record, you're referring to the President's executive order from July 2011 that sets all of this out, but the SEC has not taken any positive action.
Exactly. I mean, across industries, a review of regulation should be done to determine if it's even necessary anymore, let alone the impact on the economy. So the fact of this bill seems to be that while everyone wants it done, including the President's executive order, apparently, from my seat, it's not being done. And what I like about the bill, besides its common sense approach, is the fact that it requires a report to be made to Congress that it is in fact being done. So it's a pretty simple bill with simple outcomes, but important outcomes for the economy as a whole.
Thank you. Mr. Quadman.
Mr. Hurt, number one, the Jobs Act itself is chock full of regulations that were outmoded that the SEC could have modernized on its own and did not do so. As I mentioned in the last hearing as well, we also issued a report last year where we identified 15 to 20 regulations in the corporate disclosure area that are outmoded and out of date and no longer make sense in the 21st century economy. I believe also Executive Order 13563, the Obama administration ordered executive agencies, which are under their direct control, to do such a retrospective review, which is currently underway. I just want to just mention one point which was raised earlier, which Professor Bullard mentioned. If he had read page 6, paragraph 3 of my testimony, you would have seen what our position was on the tick size piece.
Okay. I guess another question that I have is, Mr. Quadman, do you think that the 5-year time frame in order to kind of get this decennial review on a timeline, on a regular timeline, is that 5 years enough for the SEC to be able to conduct this for significant regulations?
Yes, and that's why I made the suggestion that this be prioritized with economically significant regulations, then thresholds. I think with a 5-year timeline, you could do that. With the decennial period on top of that, you can get at the lower hanging fruit. The problem with previous reviews has been it's been a lot of window dressing. So either there have been meaningless regulations that have been looked at, or they've just been swept under the rug. So yes, that timeline, I think, provides the process that could be built out.
And I'd love to work this in real quick. Mr. Bullard, you said that you believe that the APA should not be applied to this if it goes forward. I think I'm correct in your statement, and I was wondering if I could get Mr. Quadman's response to that, to your assertion that APA shouldn't. Go ahead,
Sure.
Mr. Bullard. Do you want to articulate your position? Mr. Bullard, if you want to quickly articulate your position, and then if Mr. Quadman has time to respond.
Sure, it's primarily an administrative issue. The burdens on the SEC of having to deal with both APA requirements and the litigation that would follow would, again, just throw gum in the works and make it difficult for them to do their jobs.
Okay.
So, and otherwise, I just think it's necessary, given that you can communicate on the basis of rules anytime you want. I filed the rulemaking petition. The SEC adopted the rules.
Mr. Quadman, real quick.
Transparency is a good thing, and stakeholders should have the right to explain to their government why regulations may be working or not working.
Okay. Thank you. Thank you, Mr. Chairman. My time has expired.
Gentleman's time has expired. Mr. Scott, recognized for 5 minutes.
Thank you, Mr. Chairman. Tell you what a little bit concerns me about the venture exchange. From my reading of it, it seems that it permits venture exchanges to operate with lower listing standards for issues and exempts them from some requirements and from some investor protections that are applicable to the other national security exchanges. Do you all feel some concern about that while the intent is very good, there's no question about that, but reducing investor protections in this venture exchange bill tends not to put the consumer concerns and protections in proper focus. Do you have any concerns about that? Yes, sir.
I don't think it meaningfully reduces the key consumer protections or investor protections. It doesn't change anything relating to fraud with respect or misrepresentation at the federal or state level. It doesn't change disclosure requirements. It does alter the way that markets are made, and it does reduce the listing standards in the sense that you don't have to achieve New York Stock Exchange governance requirements or New York Stock Exchange capitalization requirements. But those, if you impose those sorts of requirements on small cap companies, they're not going to be able to ever be listed. So that's almost a necessary predicate to going down this route of having an intermediate level exchange. So I understand your concern, but in this case, I really don't think it's warranted.
Okay, but if the bill reduces certain disclosures, it reduces compliant costs, don't you think that might make it more difficult for investors to properly evaluate the companies as a potential investment?
If it did that, I think that there would be cause for concern. But any of these companies are either going to be registered companies that have to comply with the smaller reporting company disclosure rules, or Reg A companies, which a lot of people call mini registrations. It's a hop, skip, and a jump from being a public company. So these firms all have very serious disclosure obligations with respect to the key things that investors need to know to make an informed investment judgment.
So why would we have two sets here? One for these venture smaller operations and with the national firms? Why would we have certain protections for them, for the customers, and not for the investors, but not here? That's sort of what I'm trying to figure.
David, you feel free to jump
in. I don't think it really changes investor protections at all. I think if there was, and from a disclosure standpoint, it was already Title II of the Jobs Act with Regulation A+. I mean, this Act doesn't speak to disclosure per se. And actually, the thing that I'm concerned about in the current functioning of stock markets is that listing standards on both the New York Stock Exchange and NASDAQ are actually quite low or quite accessible. It's not the listing standards that are the problem. What the problem is that the companies, that the whole ecosystem has collapsed, meaning smaller broker-dealers to take these companies public and support them, that the economic model doesn't work. And I think that what the Venture Exchange Act allows you to do is to create an economic model that will get firms back into the game to support small companies once again. But I don't think if there is an investor protection issue, it would be around sales practice abuses. And my view there is that the right way to deal with sales practice abuses is through enforcement, not prevention, not to kill the goose that lays the golden egg.
If I could just disagree with it, I don't think the question is really being answered. The question is, why should there be listing standards that are developed completely outside of the Reg NMS and the Reg ATS structure the SEC has created, which Mr. Burton in his written testimony has agreed is inappropriate as a wholesale exemption, and they should not. What will happen with the venture exchanges is you will now create something that is outside of a very good structure where the SEC, unlike in many cases, has been very effective and extremely responsive. And there's really no reason to do that. If you look at the OTC Markets website, what you will see is a pretty thorough and entertaining set of standards that they've provided for these small companies within the existing regulatory structure. They require that a skull and crossbones appear next to a lot of listings. I think the message there is pretty clear. But apparently Congress wants to get into the business of deciding whether private businesses should include those kinds of warnings. That is the issue, and that's the question that's not really being answered here.
OTC Markets does it as in compliance with their own rules. The skull and crossbones is not dictated by ETS.
I did not say it was.
I know that.
But aren't they subject to Reg ATS?
But the venture exchange legislation would be basically comparable in many respects to what is currently done on Regulation ATS.
Why don't you support complete wholesale exemptions from Reg NMS and ATS? In your testimony, you said you did not support that. Are you changing your position?
Well, with that...
I'm not supposed to ask the question.
There you go. It was just like the skull and crossbones. It was entertaining. Well, to hear the back and forth. With that said,
I haven't changed.
I now turn to Ms. Wagner. Is now recognized for 5 minutes.
For the most entertaining round of questioning. So I thank you all, and thank you, Mr. Chairman. I've submitted, as I mentioned earlier, a discussion draft, the Accelerating Access to Capital Act of 2015, which would allow smaller companies and emerging growth companies that have an established reporting history with the SEC to use the more simplified Form S-3 when offering securities. Once again, this is an idea that the SEC's own working group on capital formation has recommended previously, but has seen no action on since. I'm going to do kind of a lightning round here, so work with me, gentlemen, if you would. Mr. Wild, this series of questions, sir, is for you. In comparison to the Form S-1, how does Form S-3 relate in terms of costs to small issuers?
It drops the cost very significantly, allows you to pre-approve, pre-register securities and take them down opportunistically without any inhibition whatsoever to get into markets. And in my written testimony, I'm actually for expanding the application of Form S-3 to smaller companies.
How does being able to offer securities off the shelf under Form S-3 help small issuers?
Well, I was the one that did the first overnight equity offering off of a Form S-3 shelf registration back in the 90s, because with the rise of hedge funds and manipulative institutional investors, they were the more that you hung out as a company marketing a security, the more that investors, certain types of investors, would poach and short the stock and manipulate the stock price to the adverse consequence of the company. So this allows them the flexibility of getting in the market by taking less price risk, and I think it's very beneficial. It drives down the cost of capital for corporations.
Given today's accessibility of documents filed with the SEC available over the Internet, is the one-third cap on securities offered through Form S-3 still necessary?
Yeah, I think the concern is the level of dilution in a company and people not having an opportunity to react to it, and I think it's frankly that particular point is something I'd rather let the SEC decide. And I would defer on that one, but I think it's very important because the market structure is so dysfunctional low end. We work with some really small cap companies that it's grinding up value for these corporations. Managements are struggling with it to get the support. They should be spending their time running their businesses, and so our view is that we really need to worry about the systemic risk of not starting businesses, which is what we're seeing in the economy. It's probably the bigger threat to the U.S. economy. It's not the flashy systemic risk of flash crashes and credit crises and things like that, but it's just as important and it's just as big a threat to the long-term survival of this country.
Thank you, Mr. Wild. And now, moving on to the flashy, Mr. Quadman. How does the requirement that securities be listed on a national securities exchange for Form S-3 hinder the ability of smaller issuers to raise capital?
What you're creating is what we have now is we have a system where the costs and the compliance costs without the information that's going to be useful for investors is actually inhibiting the ability of businesses to go into the markets. So I think if you take this bill in conjunction with your 1723 bill, you're going down that road of creating a company file that allows for information to get out to investors without the inhibitions to raising capital.
To Mr. Wild's point, Mr. Quadman, why do federal securities laws treat all issuers as if they are all large, highly sophisticated companies?
Well, I think this is where Congress made a very important point with the Jobs Act that has been very successful, is that we need to split it up. We can have the traditional public company, but then we also have to recognize that for an emerging growth company that are acting in these thinly traded markets, we need to give them a little more. So we've actually done a pretty good job of balancing investor protection and liberalizing some of the disclosure requirements, which I think goes to Mr. Scott's point. And I think this also allows for, because remember, these are companies that are registering with the SEC already, providing for that registration, getting the information out, yet getting rid of some of the inhibitions that have been preventing this from happening. So it's not that the information isn't going to be there or that the SEC cannot oversee this to prevent abuses from happening.
Does this bill recognize, you think, the difference between small and large companies, and how else I would say, can we further recognize that difference in our securities law?
Well, I think what your bill does is it by allowing this change, you're getting rid of a hurdle for these companies to go into the market. So I think it actually speeds it up and it is helpful. I think in conjunction with Mr. Garrett's bill, you start to put these things together and you actually create competing mechanisms against existing systems. So that's why I said in my oral statement, you're actually creating competition which should work. And the reason why we called for a study by a date certain is you can look at all these things collectively to see what's working, what's not, and what can be adjusted.
Great. Thank you very much. I yield back.
Gentleladies yield, and I just want to correct the record. Did you say you were moving from the flash to the flashy with Mr. Quadman? Is that what we were saying?
I was speaking about highly sophisticated companies versus smaller and emerging growth companies, but whatever stands.
Okay. As long as it's not a flash crash.
Thank you. Recognized now for 5 minutes.
I'd like to thank the Chairman and Ranking Member for the time. Mr. Bullard, do you have any concerns about H.R. 1965? That's the bill that exempts two-thirds of the firms from submitting XBRL data.
Absolutely. I think we just heard a reference from Ms. Wagner as to the importance of that information being accessible. And I can tell you as a professor, it's extremely frustrating, even being very familiar with EDGAR, trying to find information and decipher it. For example, the SEC still does not require the most obvious way to let people know what changes in registration statements has happened, which is require people to provide a redlined version. And I mentioned that at a PCAOB Advisory Council meeting at which Chairman White was in attendance, and we still see no movement there. The SEC continues, and I think everyone in this room would probably agree, to be a 20th century agency in terms of technology, and in eliminating any kind of accessibility information is exactly the wrong direction to go.
What are other countries doing in terms of this registration?
I have no idea.
Okay.
In terms of use of extensible markup, anybody?
I guess my question is, would this put the United States at any kind of a competitive disadvantage?
Well, I think it weakens our position. If I had to guess, I would say we're probably much more technologically advanced than other countries, but I haven't looked at that question.
Okay, thank you. Turning to another question, I'd like to get some of your views regarding the policy implications of Accelerating Access to Capital Act. Myself and 25 other Democratic members voted against the Wagner bill last session because we were concerned that the bill reduced important information to investors. Do you have any concerns that this bill could reduce information to investors?
Yeah, I mean, that really is the issue. The bill asks the right question that the SEC should be looking at, and that is with respect to the paragraph 6 opportunity for an entity that has less than a $75 million public float. Should they still be subject to a restriction on how many securities they sell as a percentage of their float? And that's what Mr. Wild was referring to as the dilution problem. And I think reasonable minds can disagree about that. But the SEC, when it established that float, had originally proposed a 20% float. It did some research to answer the question asked before as to whether it was an appropriate number, and they were persuaded to raise that number. Unfortunately, I was not able to find any further research on where that number is, and that's exactly the kind of research that the SEC should be doing on an ongoing basis and is animating Mr. Hurt's concerns. But those kinds of issues that are extremely detailed really need to be considered by the SEC. But it's not fair to ask me to defend the SEC's capacity to do that review. I think that is a separate issue, and I agree they may need to be required to look at those questions, because I think it's asking exactly the right question, it's looking in the right direction, but Congress is not the place to do that.
So as I indicated before, last May is when we looked at this bill before. Have there been any developments since that time that bear on this issue of whether this is the right approach?
As to the use of Form S3?
Yes.
Nothing comes to mind.
Okay, never mind.
Really change that environment.
Yeah, my staff recommended that question, so we'll just move on along. All right.
Well, my staff failed to give me an answer.
No problem. Anyway, last Tuesday, the SEC announced its approval for a 2-year tick-size pilot program, which would study the impact of requiring small company shares to be quoted or traded in nickel increments. Considering the SEC action, is the Garrett bill appropriate?
Well, I think it's an example of the SEC doing exactly what it should be doing in many areas that are the subject of some of these bills, and that's looking at flexible options and doing a lot more experimentation. We really need the SEC to stop feeling that if it adopts a rule, it has to apply it to everyone because it feels it has to defend any potential failures on just one front. We need to see a lot more of that. The SEC is doing it, and then requiring that you have a venture exchange that has nickel pricing is really interfering with and undermining that effort by the SEC. The current structure of the regulations that apply to exchanges, where I think you have over 90 ATS exchanges, has created an enormous amount of diversity in that market, and we need to reward the SEC for providing additional flexibility in the form of the pilot program and not undermine it by creating competing exchanges that have provisions that will be very difficult to change given that they're in statutory form.
That's the end of my time. Thank you. I yield back, Mr. Chair.
Thank you. The gentleman yields back. The gentleman from Arizona is recognized for 5 minutes.
Thank you, Mr. Chairman. And to my friend at the other side, My staff has just stopped writing questions because apparently I don't ask them. There's actually, I'd love a little more depth on the discussion on researchers being able to publish on ETFs. And for whoever feels they have the most competence on this one, I sat through a seminar a couple weeks ago, and it was the first time I'd come across something called a managed ETF, where how does this work? What happens with the information? Tell me why it's wonderful.
Well, I've spent a lot of time in ETFs. I was at the SEC in the office that approves them when they were first being approved. And the managed ETF is a new product that should have been allowed to come out a decade ago.
Yeah, but it's now starting to get some legs.
Right. And what it does is it uses a particularized pricing mechanism that still relies on the close of the day NAV to be the price at which you buy, rather than actually buying at an ongoing price on the market.
Please understand, I'm sort of a fan of the concept. My interest here was for whoever's on the panel on my ability as a researcher to put out data saying, here's the concentration risk, here's these things. Because right now, I come from a world where I think it's absurd there's a restriction on putting out information.
Well, research, we should all be for transparency and for more information, and it's a safe harbor that's required so that you can put out more information on a sector of the market that's growing very fast. And so it's very hard to understand any objection to providing thoughts on a product that's now $1.6 trillion, and it'll be double that probably in a few years. It's a very fast-growing product, and the SEC rules are outdated with respect to that product.
Well, side question on this, is our language broad enough to make it the publication of research information on a managed product?
It would be broad enough to allow an enormous amount of research by issuers, broker-dealers on products that aren't even ETFs. To get to the substantive answer to the question, I don't see it as a size issue. It's that essentially registered investment companies are pools of securities. They are not operating companies, and they are in continuous registration. So the risk of the underwriter, when going to market in an IPO, putting out these research reports essentially as a way of conditioning the market, does not exist for these types of products. And the SEC should have had a completely different, much less regulated track quite some time ago. But it's just as applicable to other registered investment companies as ETFs.
Well, you said something, actually, I want to come back, but this is sort of a follow-up from a conversation for Mr. Quadden. Is there, I come from a view of the world that the best regulation is ultimately sunshine, information. Do you see a problem here? I mean, is the ability to publish research and attach it to your offerings, wouldn't the ultimate solution be trying to have as robust of information environment as possible?
Yes, and I agree with Mr. Krzyzewski that we need to have that safe harbor to allow that to happen, because what we've had now is we have two separate standards that have developed that with broker-dealers. There are safe harbors that allow for some research, and that allows investors to make decisions, but with ETFs, we don't have that. I think also, Mr. Bullard also makes a very good point as well. Markets are dynamic. So we're talking about ETFs today. We could be talking about another product 10 years from now. So I think we also want to be flexible to allow for those safe harbors to provide for those research to benefit investors.
Okay. Mr. Chairman, just probably one or two last. Professor, you actually said something earlier that sparked my ears, and I know you sit on which committee over at the SEC?
I was at the SEC's Office of Exemptive Applications, which is where you would go to create ETFs originally.
And a little while earlier in the testimony, you said the rulemaking right now is dysfunctional.
Yes.
Is that an argument for us to be substantially more prescriptive when we work on pieces of legislation here? Because, I'm still, is the word outraged or enraged, on crowdfunding, on some of these other things that we passed as our goal to try to, expand opportunity for everyone, and we're sitting here, 3-some years later, and it's still trapped over there. There's something horribly wrong at the SEC. Should we become dramatically more prescriptive to them because of their inability to do their job?
I would agree in terms of mandating rulemaking, but I think that ultimately it's counterproductive to become prescriptive in the sense of detailing the rules.
When you say mandating, and sorry, Mr. Chairman, timeline?
Timelines.
Self-executing?
Right. Broad policy, just tell the SEC, create an exemption for registered investment companies from 139 and do it within a year.
Okay. Yield back. Thank you, Mr. Chairman.
Right. Or else.
Well, there's nowhere else, unfortunately. But
and there is the rub, isn't it? Mr. Carey?
Thank you, Mr. Chairman. First, let me apologize for not being able to hear most of the hearing up to this point, but I'd like to ask a couple questions about the two bills. By the way, when I speak, I don't have questions that my staff wrote, but when I speak, you can see Craig's lips moving over there, and it's actually coming from him. But I have interest in the ETF bill, which Congressman Hill's been working on, and I'd like to be part of that and work with Mr. Duffy a little bit on the venture exchange bill. There seems to be some consensus that making greater access to research for ETFs makes a lot of sense. Is there anybody on the panel who disagrees with that? Did I miss anything? And so then my question would be, is there anything, it goes, I think, to the question that Mr. Schweikert just asked about how prescriptive legislation is. Is there anything in the draft legislation that has been developed that raises any concerns by any of the panelists?
Well, I've highlighted in my testimony essentially a laundry list of issues. One is the extent to which it departs from the basic foundation of Rule 139. Of greater concern is it provides a sweeping insulation from private liability, which I don't think was the author's intention. But if you look at the way the bill is drafted, it eliminates generally liability for the research reports to the extent that the liability depends on there being an offer.
The safe harbor provision. You think that there's an opportunity to clean that up or make it more reasonable?
Again, I would rather work from the point of view of asking the SEC to do a registered investment company exception, because the current departures from Rule 139 in the bill, I think, would be hard to fix, and it also would remove any flexibility the SEC would have going forward in changing the rule for the benefit of ETFs down the road. You do something in a statute, you essentially locked it in place, and the SEC would not be able to make it liberalize it or strengthen it in the future.
So you would argue for doing something less prescriptive rather than more, going back to the question from Mr. Sweat?
Yeah, less detailed, but I think if this is what you want, you tell the SEC to do it, and as Chairman Garrett suggests, you these days have to give them a timeline.
Right. Any other panelists have a different view of that? So a second question or second issue is venture exchanges. Mr. Duffy and I have been talking about that for some time, and know others as well. And we spend a lot of time back in our district, and I was talking to a woman who runs a large corporation pension fund and raised some concerns about it, which surprised me, frankly, with respect to starting a venture fund exchange, excuse me. What are concerns that any of the members of the panel might have on that idea?
Mr. Carney, not necessarily a concern. I think
her concern was basically that the unsophisticated investor could really be taken for a ride in a venture exchange.
Yeah. What I have in our testimony, and I also talked about in our oral statement, is that I think there needs to be the ability for the SEC and the exchange, right, when they're developing the system, to develop it in such a way that you have sufficient investor protections in place and they have sufficient systems in place to allow that exchange to operate. I think we can get at those concerns through that process. Additionally, as I said—
Through the process of setting up the exchange itself?
Through the process of setting up the exchange. But then the reason why we also asked for a prospective prospective study on it is to take a look at it in a date certain in the future, to see how the venture exchange is operating, if there are changes that need to be made, and then also to see how it's operating in competition with the OTC markets, with ATS systems, to see how that's all working. So I think we have two bites at the apple to take care of those concerns.
Good. Mr. Burton?
I think that maybe your constituent didn't fully understand the proposal, which is understandable because it just got
because I explained it to
her. The venture exchange is really a question of how you structure the marketplace. The individual investor can go buy those stocks because they're public companies on OTC markets over their E-Trade or Ameritrade account today. Right? And the way the proposal is structured would also include the new Regulation A+ securities, but they also have quite a bit of disclosure and probably are going to become tradable as well. So I think the investor protection core of it, particularly the fraud rules at both the state and federal level, but also the disclosure rules at the federal level, are sound. And that's not really what the legislation addresses. It addresses the structure of the marketplace and how that can be changed to make smaller capitalization firms have a better secondary market, which will help investors, not hurt them, because they'll have a more liquid market where they can sell their securities when they need to, and they're more likely to get a better price.
Thanks so much. I see. I'd love to hear your response, but I'm out of time.
Thank you.
Yield back.
The gentleman yields back. Mr. Huizinga is recognized now for maybe the last 5 minutes.
Well, thank you, Mr. Chairman. I appreciate that. Mr. Krzyzewski, I've got a quick question for you about this particular bill with Ann Wagner. I'm going through your testimony. I didn't see whether you supported or opposed it, or SIFMA does.
Congresswoman, the
Wagner's?
S3 Wagner's bill?
Yes.
We did not comment on that bill, no.
Any reason why?
Well, I think first of all, everything that's been said here, from venture funds or venture exchanges to this bill to research, is a recognition by this body, which I applaud, that the cost of capital for small companies is extremely high, and we're not creating the jobs we should from the job engine, which are small companies. Ms. Wagner's bill attempts to do that, and you're trying to balance access to capital with investor protection. And all I'm saying is I'm not sure where that pivot point is, and I'm not prepared to discuss that today.
Okay. But you're comfortable with the time frames that the SEC has been dealing with in not acting on this?
I didn't say that either.
Oh, okay. All right. Well, I'm curious because you seem satisfied when it comes to my bill that the SEC took 7 years to act on anything, and we have a no action letter. But Mr. Quadman, I'd like for you to maybe comment transitioning to my bill, which wasn't formally what we were going to be talking about with the mergers and acquisitions, but I know Mr. Krzyzewski had decided to spend a considerable amount of time on it. Just curious if you'd like to comment on some of those points.
Yeah, as we discussed before, I think what your bill is important is that many businesses today are looking to be acquired, so that your bill allows for that activity to occur on an easier basis. The problem, as I raised before in the last hearing, well, I think the SEC no action relief was a good thing. What we have also seen in the past is that what the regulator giveth, the regulator taketh away. So in the area of corporate governance this past January, on the Friday night before Martin Luther King's Day weekend, the chair on 6 o'clock at night decided to overturn decades worth of past staff practice in the Whole Foods decision. So the unfortunate part is, with no action relief, it does not provide the necessary certainty going forward, which is what we think the bill does do.
Sorry, I appreciate that. And I guess that is a significant concern I have as well. I mean, the SEC had this recommendation listed as a priority for themselves for I believe it was 7 or 8 years. It did not do anything with that. A no action letter isn't binding on the law. There's no size cap today with that, as is my understanding. I mean, we're talking about 25 million EBITDA, but we're also dealing with 250 million in gross sales. So it doesn't. It seems to me that we are limiting this, and I'm hoping that we're going to be able to move through this. And I understand why SIFMA may be wanting to protect its members, shielding them from protected territory that they have. But there's nothing in the bill that is going to to deny them referrals, actually, that we believe will help the flow as Mr. Wield is talking about it, trying to get deal flow happening. That we believe as it gets pushed down that stream, that will actually allow for capital to get freed up. We have $10 trillion estimated dollars tied up in these non-public, closely held businesses that, under this legislation, would only apply the ability to use this if that business is purchased and then run by the purchaser, and either wholly owned or either directly or indirectly controlled by that buyer. So it seems to me it's a bit different than the Facebook example that was brought up. So I've got 20 seconds, but having 5 reasons named Garrett, Adrian, Allie, Will, and Seeger why I'm here in Washington, I just want to applaud you for taking your son here today and letting him see that there are people that are concerned about not just our own interests, but yours too, buddy. We want to make sure that you've got the same opportunities that your dad's had, your mom has had, and that those of us here have had. So I'm glad you're here with them today. And my time has expired. Thanks.
Thank you. The gentleman's time has expired. Appreciate those comments. Mr. Poliquin, front row.
Thank you, Mr. Chair. Thank you, gentlemen, for being here. I appreciate it very much. I represent Maine 2nd District, which is the most rural district east side of the Mississippi. We have a couple population centers like Bangor and Lewiston, Auburn, have about 35,000 people in there. We have 400 small towns. We have 70,000 moose and about 35,000 bear, and most of them vote. So it's a great place to live. If you haven't been there, you should get back there as soon as you can, because we need the business now. We all know that this has been about the most anemic economic recovery in 80 years. We have a lot of folks in our district that are working 2 and 3 jobs, part-time jobs, replace full-time jobs across the country. Millions have just given up working, and we have the lowest participation rate in probably 30 years. So it's not working. Now, in our district, we have tens of thousands of small businesses. Now, many of them might not be in your space, but we're a district and a state of small business owners, and we know firsthand how costly overregulation is, and how it causes people to shut down their business or pass on their costs if they're able to the consumers, which raises fees and reduces options and opportunities for our consumers. Now, I'm looking at these bills that Mr. Hill and Congresswoman Wagner and Mr. Garrett and Mr. Hurd have all put before you folks today to comment on. They all make a heck of a lot of sense to me. But what I'd like to do is drill down a little bit more, if I meant, Mr. Kruszewski. I believe you're the first individual that's come before this committee or a subcommittee of this committee dealing with fiduciary standards, a new rule that's now before the DOL. And I happen to believe that if you have brokers, and there are about 600,000 of them across America that work for your firm and other places in this space, that, in my opinion, are regulated properly, and now they're being proposed to be held at the same fiduciary standards as some of the largest money center banks in the world. I'd like to hear from you, sir, if I can. What do you think that'll do to the customers that your brokers serve, whether they have an IRA or 401k, or they're a husband and wife, they're planning for retirement, or maybe they're folks saving for their kids' college education? What does this do to you as far as running your business, and the type of information, the type of counsel that you folks might or might not be extending to the folks on the other side of the transaction?
You're speaking of the DOL
Yes,
proposal?
I am.
It's an interesting to stand here and testify on a bill that, from a business perspective, and I run a company where the implementation of this bill as written, and it's a very complex bill, would be financially very beneficial for most companies. This deals with non-managed small IRA accounts where we would be pretty much, we would have to, because of legal and other matters, to charge these accounts fees. In a very simple way, I would tell you that, and I've done analysis, we would raise the cost of our small IRA investors by 75%.
And when that happens, what does that do to the rate of return on those investments for those folks who are trying to prepare for their retirement?
Well, it's again, it isn't necessarily. It would obviously go down by the amount of fees, just by pure math. But the fact of the matter is that this is a bill that I think imposes additional cost and limits choice, and there's and I find it somewhat ironic as when I look at it purely financially, it's over $100 million to my firm alone if I just applied fees to smaller investors that I do to my larger managed accounts on a percentage basis. So it's interesting, and I think it requires a lot of debate. I think there's a lot of investors that do not understand the cost, or if they want to avoid the cost, then they're going to have to leave this model and do it yourself. And I think a lot of investors don't want that. Mr.
Williams, you've been in this space for a long period of time. Tell me your thoughts with respect to this, sir, in particular when we have a government that's increasingly encroaching upon our small business community and every facet of our lives, and they're more and more dependent on the government, but we have a Social Security system that's about a $15 trillion unfunded defined benefit pension plan. What does this whole problem do to the folks you've been experienced with as far as serving their clients and making sure they do not run out of money before they run out of time?
Well, you look at, in our testimony, we have labor participation rates in there, and we've done a round trip on them. We've gone all the way back to where we were in the late 70s. But interestingly, the 16 to 19-year-olds aren't getting work, which is important, I think, particularly to lower-income communities where kids need to kind of get assimilated. But also, if you look at this over 65, the scary part is that the one part of the economy where the labor participation rates are going through the roof is people over 65, which means they can't retire. They're scared to retire. They're clinging on to their jobs. So this is a sign of an economy which is really, really incredibly unhealthy. And then when you look at the Robert Lighton numbers on startups from the late 70s, where 15% of all companies were less than a 1 year or less than 1 year in age, and now it's down to 8%. I mean, holy mackerel! If we're not scared, we should be petrified right now. We are not getting things moving on the low end of the economy, and that's one of the reasons why the Venture Exchange Act, Congressman Scott, is, I think, so important, is because it institutionalizes the discussion around what we need to do for small companies. And I think that in and of itself will be incredibly helpful. If you look at SEC committees, sort of the stepchild of the Division of Corporation Finance has always been the small business area of the Division of Corporation Finance. They have a small business forum every year. They make lots of recommendations. The recommendations tend to go nowhere. And meanwhile, so what we're doing is we're fiddling while the United States economy is burning. We have to correct this. And so taking on more risk, and small companies fail at higher rates, and people losing some money, that's okay, because if you think about it in the aggregate, it's not big numbers when 80% of your publicly listed companies, NASDAQ and New York, are under $2 billion, but they only represent 6% of your aggregate asset value. I mean, but it's outsized in terms of its job impact on the U.S. economy. So we need a different way of looking at these things, and I think that's one of the reasons why this Venture Exchange Act is absolutely critical to our long-term American interests.
Thank you all very much. I appreciate you being here and participating in this process. Mr. Chair, you back my time. Thank you, sir.
Thank you. And once again, Mr. Poliquin, appreciate the advertisement for Maine. So Mr. Hill is recognized now for 5 minutes.
Thank you, Mr. Chairman. Appreciate the panel being here with us. Thanks for your tenacity of sitting here this long. I want to appreciate your comments that some of you have made about the discussion draft that I've put forward called Fair Access to Investment Research. In my view, this is a common sense proposal which mirrors other research safe harbors that have been implemented by the SEC and would clarify the law allowing broker-dealers to publish research regarding certain ETFs, allowing investors access to this information. Since I started my last brokerage firm in the late 90s, I've seen this area explode, and I think that's been talked about today, from about 100 funds with $100 billion up to today's market with over 1,300 fund offerings and over $1.6 trillion in assets. And that speaks to this issue, I think, handily, particularly whether they're managed or used in a managed account or whether they're bought standalone. So there are now 6 million households that are using ETFs. And to the professor's point about longevity, and I do appreciate being accused of dropping a nuclear bomb. I think Washington needs a lot more metaphorical nuclear bombs in the regulatory system, so thanks for the compliment. But looking back at the regulatory history, the Division of Investment Management in 1987 was asked by Charles Schwab to provide no-action relief in this area. It declined. Merrill Lynch approached the Division of Investment Management regarding no-action relief for open-end investment companies in May of 2000. The staff supported it, perhaps you were there then, but never took it up. In 2004, as a part of the securities offering reform proposal, the Commission requested comment on whether reliance on proposed Rule 139 should be permitted if an issuer is an open-end management investment company or another investment company. Again, all the comments were positive. Nothing happened. And it's to the Chairman's point. There is no or else in Washington, D.C. And if you think we like to have prescriptive legislation directed at our independent regulatory agencies, you're mistaken. The problem is in this society we have no choice now because we have no responsiveness from our independent regulatory agencies, whether they're subject to the appropriation process or not. So I do appreciate your comments, and I thought they were very helpful, and I appreciate them. And to Mrs. I think that addresses maybe Mrs. Maloney's point, but one other I would add is that this safe harbor is still pursuant. These firms are still subject to FINRA's Rule 2711 governing research, and of course these are all subject to the anti-fraud provisions of the Commission in Rule 10b-5. So, this is not some grand sweeping out of the ordinary proposal. So, with that, I'd like people, maybe if you'd like Mr. Bullard to respond to that, again, add your thoughts.
Sure. I think you said that it mirrors the existing approach, and there's a paragraph in my testimony that gives 6 or 7 examples of how it goes further, one of which is that it allows issuers to issue the reports. It's not limited to broker-dealers publishing them, and under 139, issuers aren't allowed to publish anything. So that's one major difference. Another is, I think you mentioned, it doesn't affect anti-fraud provisions. It actually is a carve-out that would prevent the SEC from bringing a Section 17 enforcement action because of the limit on liability. And I don't think those were necessarily intended by the rules, and it's obviously something that happens when Congress, dealing with the full breadth of the world of legislation, tries to rewrite an SEC rule. I cannot defend the SEC. When I was there, I saw this, and it's one of the reasons I left, is that it's an agency that, unlike a lot of other federal agencies, has 5 or 6 tiers rather than having, as a lot of entities do, an assistant director who oversees a lot of people. So there are structural reasons why the SEC has problems. They haven't really taken any steps to fix them. And I can't defend their not having adopted a rule. I would still, though, stand by the recommendation that give a mandate a try, and if it doesn't work in a year, then come back and bang them on the head. I agree with most of what you said, and my core area of expertise is the investment company area, and it's distressing to see they haven't taken any steps on this. Although, in their defense, exchange-traded funds are a creation of the SEC, as are money market funds, as are 12b-1 fees. So there are a lot of examples of the SEC's responsiveness having, in the past, been a benefit to both investors and the industry.
Thank you, Dr. Bullard.
Thank you. So this, with unanimous consent, I'm going to yield to Mr. Scott for an additional question or two.
Thank you. Thank you very much, Mr. Chairman. I'm very interested in this subject, and I certainly commend Mr. Garrett on the legislation. But I do think we need to really exhaust these concerns that we have about a loss of consumer and investor protections in the area. The reason I'm acquainted with somewhat with this is, as a student at the Wharton School of Finance, we did a student project at that time, and this is why I commend Mr. Garrett, because access to capital is a very serious problem, particularly in the minority community, with minority African American owned businesses, and we put together a forum, venture capital effort then to help those companies in the Philadelphia area. So my question going back to that is that if for example, the new ventures exchanges have permissive or what we call de minimis listing standards, and the securities traded on these exchanges become exempt from the state blue sky laws, does that give rise to any investor protection concerns? And particularly, Mr. Bullard, I'd like for you to answer that question, and Mr. Gruszewski, you represent SIFMA, correct, the financial institutions. I think that to help Mr. Garrett smooth sailing with this bill, we really definitely need to clear the air on this little hurdle of a great concern that consumer protections may be deflated. Could you answer that question first? Mr. Bullard, Ms. Gruszewski, anybody else too?
I guess I would separate the investor protection between the exchange-provided protection and the exemption from state regulation. Frankly, to answer the question asked, I think by Mr. Carney earlier, is that the exchanges already let you take your investors to town, and we accept that they have very low listing standards and that a lot of them will fail and that there will be potential investor abuses. My main objection is that the venture exchange would operate outside of the system that the SEC has currently been authorized by Congress to administer. It, by removing all of Reg ATS and all of Reg NMS, which are not principally investor protection provisions, but do include some, Congress is essentially undoing its own work and creating something that becomes another breed where you would definitely see new investor protection concerns arising. On the state registration side, I just haven't seen out of Congress a coherent approach of when, if ever, they think state merit review is appropriate. Now, if Congress just wants to eliminate states altogether, that's one thing. But to arbitrarily have cutoffs as to when the states are allowed to regulate small offerings, especially when it's flatly consistent with what I understood to be the deal when the Jobs Act was on a bipartisan basis approved, I think is inappropriate.
Mr. Gruszewski?
Yes, I would just say that I think it's very important at the highest level to separate investor protection from the liquidity and the market access that we're trying to achieve. I don't think this bill in any way, or not, I shouldn't say in any way, to the extent that you increase liquidity and capital, you have more companies that potentially can fail, and that's part of capitalism. So I'm not going to suggest that. But this cannot be about investor protection. It's not. This is about, in many ways, undoing some of the things that have destroyed the ecosystem for small companies. And many of the rules that were put in place has destroyed the ability to do this. I represent many companies that we have to sell that could be job-creating machines because they do not have access to the capital markets out of certain of their growth funds, or their growth stages. And so I believe this is a very important issue, and it's not an investor protection issue. It's a liquidity issue and a trading issue for small companies. Excuse me.
And the both of you are very comfortable that the SEC has the resources available to monitor these new exchanges and the securities traded on them?
No, I don't believe that it does.
Well, they're already trading. Many of these are already trading. I don't understand that comment. They're already trading. We're talking about providing a marketplace that supports the growth and formation of small companies and, by an extension, jobs in this country.
The complexity of the markets, really came from all the legislation and all the rulemaking that created Reg ATS and NMS and decimalization, the proliferation of trading venues. There's over 50 trading venues, and that in and of itself has put the SEC on this treadmill of trying to keep up with the sheer volume of complexity that's occurred. These markets are actually be much simpler, and interestingly, Congressman Scott, if you listen to the language coming out of the SEC is questioning openly now the wisdom behind one-size-fits-all markets. There's definitely an interest on the part of the Commission in re-examining this along the lines of what I think this bill does.
Thank you for your courtesy, Mr. Chairman.
Thank you. And so I'll leave it at that, and maybe Mr. Wheel's final comment was the comment that we can take away on this is that the simpler you, although it will be changing the law, the simpler that you can make something sometimes actually inures to both the benefit of the marketplace, but also inures to the benefit of the investor as well. That if it's clear exactly where I'm trading and what I'm trading, it's good for him, and it can also be good for the agency as well, that they don't have the complexity in these other areas and continually fighting in these other areas as well. So, and also the other takeaway earlier in your comments was, what? Well, that actually is Mr. Bullard's comment, that there was nothing in M&S really, not nothing, but nothing really about from M&S was not really about investor protection, and that's really what we're not talking about those issues as well here. That was Mr. Wheel's comment. We're really not talking about those wheels here. At the end of the day, when we have if and when we have a final draft on this, maybe we just sort of restate that. To restate that, what we're going to our intention here is not to be focusing on those areas, to ensure that all current investor protections are in place, and they will continue to be in place for these stocks that are already trading. How we word all that, we just want to make sure that that message comes through. So with that, we're expecting one other member, but he is not here, so he misses his chance. But he doesn't miss it entirely. As we come to the conclusion of today's panel, I thank the members of the panel for being here, and without objection, the hearing record will remain open for another 5 legislative days, and why that is significant is for both those members who are here and those who did not get here today. They were able to submit written questions to the panel that we would then ask that you would return to us so we can put their responses in the record. Also, all members have an additional 5 legislative days to insert extraneous written materials into our record as well. So with that, I very much appreciate the education and the insight from your various perspectives on the various bills that we had today. And with that, this hearing is adjourned. Thank you.